Okay, so we're done with the first chapter of our discussion. We've discussed what post-clearance audit is, what its objectives are, what the benefits are, which can be derived from post-clearance audit, and we have also discussed the types of post-clearance audit. So we proceed with the next topic, particularly the legal framework and essential powers involved in the post-clearance audit. So before we do that, we discuss first the legal and operational framework of a post-clearance audit. So when we talk about framework, first we should know what framework is. Framework is defined as a basic structure underlying a system, a concept, or text. So applied to this post-clearance audit, it is a basic structure which underlies the post-clearance audit. So when we talk about a legal framework, we are talking about the laws which support or which serves as the structure for conducting the post-clearance audit here in the Philippines. So that's what the legal framework is all about. That's what legal framework means. So here is what your WCO guidelines for post-clearance audit says about the legal framework of the PCA. So to facilitate the PCA or to facilitate the post-clearance audit, it is necessary to implement legislation which provides customs with a legal basis to conduct an audit and also sets out the rights and the obligations of the auditee. Each customs administration will develop laws and regulations based on national requirements or in cases where a customs union exists at a regional level. Customs laws and regulations should provide the following: definition of PCA coverage, the persons, company who may be subject to the PCA, the authority and powers of customs officials or auditors conducting the PCA. Number 3, the obligations and rights of the auditees. Number 4, the penalty scheme. And number 5, the right to appeal. So when we talk about the legislation and how it is implemented here in the Philippines, we see that the manual requires that the customs here implement legislation. So when we talk about legislation, we are talking about the law conducted or the law enacted which will support the conduct of the post-clearance audit here in the Philippines. So what law is that? In the Philippines, it is the Customs Modernization and Tariff Act. So it's the law, the CMTA is the law enacted which will support or which forms the basis of conducting post-clearance audit here in the Philippines. And how is that law implemented? That law, the CMTA, is implemented through various CAOs and CMOs implemented by the Bureau of Customs. And in the case of post-clearance audit, at present, that particular CAO is CAO or Customs Administrative Order 1-2019. So that is the law involved and that is the implementing rules involved in the case of PCA. So let's talk about the scope and coverage of the post-clearance audit. When we talk about scope and coverage of post-clearance audit, we are talking about the possible subjects of the post-clearance audit, whether it is a natural person or whether it is a juridical entity. So who may be subject to a post-clearance audit? This is what your WCO guidelines for PCA says. The scope and coverage of the PCA, namely which persons may be subject to an audit, should be clearly defined in customs laws and regulations. Potentially, all businesses involved in the import and or export of goods or in the receipt, storage, manufacture, and delivery of goods subject to customs controls may be audited. This may include importers, exporters, declarants, consignees of the imported goods, owners or beneficial owner of the imported goods, subsequent acquirers of the imported goods, customs clearing agents of the imported or exported goods, storage agents of the imported or exported goods, transporters of the imported or exported goods, and other persons or companies directly or indirectly involved in the transaction of the imported or exported goods. So the WCO Manual for Post-Clearance Audit, which requires a law and an implementing rule, it also requires that law to provide customs officers with the authority to conduct the audit at the premises of the auditee. So that power or that authority necessarily includes, number one, the right to access the auditee's premises. Number two, the right to examine business records, business or trading systems, and commercial data relevant to customs declaration. Number three, the right to inspect the auditee's premises. Number four, the right to uplift and retain documents and business records. And number five, the right to inspect and take samples of goods. Furthermore, your PCA manual also requires that there should be an obligation to maintain confidentiality on the part of the Bureau of Customs. So this is also for the protection of the auditee or the subject of the audit, that the law should also require that there should be confidentiality in the conduct of post-clearance audit. So the WCO manual for PCA also requires that the law, in our case it's the CMTA, and the rules, in our case it's CAO 1-2019, the WCO manual requires those to set out or to identify the rights and obligations of the persons or companies which are subject to the audit. Among others, these are the following obligations and rights which may be or which should be indicated under the law and rules. Number one, a requirement to maintain specified documentation, information, and records. The duration for retaining such records should be no less than the maximum period after importation or exportation when customs may legally demand underpaid duty and make refunds for overpaid duty. Number two, a requirement to make such documentation, information, and records available in a timely manner. Number three, a right to appeal. Number four, a right to an explanation from customs concerning determination of customs value. Number five, a right to expect confidential treatment of business documentation. Number six, a right to clearance of goods at the frontier with provision of security. And lastly, a right to amend declarations without penalty in the appropriate circumstances. So we will later on discuss further these rights and obligations of the subject of the audit. For instance, we will discuss how you can question the findings in an audit. That's the right to appeal. We will also discuss the prior disclosure program, which is also the right to amend declaration without penalty. So we will also discuss these rights and obligations more in detail later on. The WCO manual also provides that when the scope of auditees is expanded to persons other than the declarants and deporters, it will come into question whether a legal obligation for keeping records can be imposed on all persons or companies designated as complementary auditees. The problem is whether it is reasonable to impose a legal obligation for keeping business records on persons or companies other than those who have close relation to import or export transactions and customs clearances, such as the importer, exporter, a customs clearing agent, transporter, etc., under the customs laws and regulations. Other national legislations regarding the business activities, such as income tax or commercial tax law, may stipulate their obligation. The adequacy of powers available to customs administrations under national law needs to be kept under review, and powers should be modified where necessary to respond to new national and international commitments. Other non-customs legislation may be of relevance and interest to customs in the course of conducting a post-clearance audit. For example, first, regulation of business entities and their activities such as commercial law, company law, income tax law, etc. In our case, we have the Revised Corporation Code and we have the National Internal Revenue Code. Second, import or export licensing requirements. Third, foreign currency control, etc. And lastly, obligations deriving from binding UN Security Council resolutions from the UN Charter, such as embargoes, export controls, and such other similar obligations.